Hello, my name's Bob Charavelli, and if you are at the right workshop, you'll see that it's titled A New Way of Expressing Voice, the Use of Online Dispute Resolution Video Platforms at the EEOC. By now, COVID has changed a lot of your lives. And for those of us in the dispute resolution area, where we've always dealt with the divide between art and science, this has been a new opportunity to hasten the use of technology. And so what we're going to be exploring today with our panelists in the study that led to this workshop is the use of the art of dispute resolution at the EEOC and the technology. So for today, we will have the following people presenting. The author of the study, Dr. Pat McDermott. He's a professor of management and legal studies at Franklin Purdue School of Business at Salisbury University. We will have on a pre-recorded session, Arthur Perlstein, the FMCS Director of Arbitration and Director of Office of Shared Neutrals. David Allen Larson is a professor of law at the Mitchell Hamline School of Law. He's also a senior fellow at the Dispute Resolution Institute. And then we will have Steve Ikonowski, who has served as the EEOC's National ADR Coordinator since 1997. He was also one of the primary designers of the mediation pilot program at the EEOC. We are going to dispense with detailed descriptions of our panelists, but they will be provided for you if you're interested on the website. So I'm going to kick it off by turning the screen over to Pat McDermott so he can tell you about his study and set the stage for what you're about to see. Go ahead, Pat.
Thank you ever so much, Bob. Yeah, we got a great panel. So what I'm going to try to do is as quickly as possible, go through some of the data here. We wanted to make this interactive. We don't have a lot of time, but we have the chat tool. So I ask that you chat any questions you have. There's been a press release that came out yesterday that lays out the two studies that were done for the EEOC in great detail. So I refer you to that site for a lot more information. This is very, very topical data, and that's why it'll be a great help to hear from our experts. We're talking about voice today, and it could be an argument, a strong argument, that for the EEOC processes, that the EEOC mediation program is the last stop to have a voice and a positive outcome. Most EEOC charges, you get a right to sue letter, nothing more. Most parties don't pursue anything after they get the right to sue letter. There's a great deal of research that shows plaintiffs barely prevail in state and federal court litigation. So the EEOC mediation program actually adds great value. What we found is we studied the mediations. There was an online survey. The parties were asked to fill the survey out after the mediation was completed. I've got all the data in these reports, and you can feel
Robert, is it just me, or I cannot hear Patrick any longer?
I think he's frozen.
Yeah, it looks like there's been a problem with his transmission. He did say there were some storms coming in and that it would potentially be a problem with his internet connection. Let's see. I'm getting a call from him right now. Just bear with me. Hey, Pat.
One of the downsides of virtual mediation. Many upsides too.
Pat's trying to reconnect. He got hit by a thunderbolt in their storm and it knocked him out. But Okay. Pat has suggested that we just go to the next presenter. And that will be Arthur Perlstein. Arthur is in Poland now, and so he pre-recorded his comments. So we'll just go straight to Arthur's pre-recorded session.
Hi, I'm Arthur Perlstein from FMCS, and I'd like to thank Vera and Pat McDermott and his team for the honor of appearing before you today. I wish I could be with you in person, but by the time of this workshop, I'll be overseas and have unpredictable access to the internet. Though the focus of this panel is on ODR in the mediation context, I've been asked to talk to you about ODR for arbitration, which has some overlap in terms of lessons and issues. A large part of ODR at this point involves new methods to package and deliver dispute resolution, overcoming usual barriers of costs, distance, and accessibility. And this can be done through the use of the internet and related tools. And virtual or video arbitration falls under this category. I'm coming at this from the perspective of heading an arbitration program that includes a roster of almost 1,000 arbitrators, and we open over 10,000 cases each year. As you might imagine, over the past couple of years, there's been a huge increase in the demand for conducting arbitration online. And that's involved many problems and issues, but also quite a few successes and I think much promise. So I'm going to talk to you about mostly the things that I've experienced and observed, and some lessons learned. And then I'll conclude by discussing what the future may hold. So let me go ahead and share my screen. There it is. And full screen with that. Of course, I started at the end, but there's the beginning. Basically, as you know, over 2 years ago now, everything became about COVID in so many ways. And of course, it had a significant impact on arbitration in general, and certainly from my standpoint, labor arbitration in particular. I mean, there came a time when it started to sink in, become real to people, realizing that it's time to adapt. But it dawned on people at different times. The Irish hat on the puppy signifies when it dawned on me. It was St. Patrick's Day, March 17th, 2020. It's not a religious holiday for me, but it is one that I frequently celebrate, but not in 2020. So as it began to dawn on me, and I began to look at what is going on in the world of arbitration, I realized that something that I had long thought was underutilized would become very important, and that was the use of video or virtual arbitration. So we created a new option. Arbitrators indicate all kinds of information that populates a biography on our platform, and we added something that arbitrators, basically a box that arbitrators could check that would say they are video arbitration capable. And at the same time, a box that parties could check when making a request for panels from which to choose saying we only want arbitrators that are video ready. We also do a lot of other things. For example, we spent considerable effort working with the National Academy of Arbitrators to do, among other things, hosting of training for arbitrators in how to do virtual arbitration. We did lots of things to publicize the options with this and materials about it. We promoted the use of virtual hearings when appropriate, when the parties found it appropriate. And basically what we were saying is that this is an option that you should seriously consider, especially in these times. I created a guide, a sort of primer on virtual arbitration for advocates, which we posted on our website and remains there. I participated in presenting at a number of conferences and panel presentations and other trainings. One of the big issues in all of this, and I think largely underlies the resistance that there is to the use of virtual arbitration, involves what I have called the cut of their jib fallacy. This is an idea, it's a very old-fashioned expression and a very old-fashioned idea, but it's an enduring belief of many in the arbitration community, among arbitrators and parties, but it's belied by research. Basically, the expression comes from the 18th century method for being able to identify the nationality of ships from a distance. And this was done by seeing the number of jib sails and also the shape of the sails. Now it's applied sort of idiomatically to judging a person, particularly demeanor and attitude and just generally personality. And it's this part, the demeanor and general bearing of a person that is seen by many as very important in determining witness credibility in a hearing. And it's said by many to be the reason why they don't want to do virtual arbitration and not have a hearing virtually because, and believe it or not, I had several arbitrators and party representatives actually use the phrase, I can't, it's important to get the cut of their jib at an actual in-person hearing. But the truth is that we humans are actually very poor at determining credibility based on demeanor, facial expressions, movements, and so forth. There's a growing body of empirical research that bears this out. And that's why I refer to this all as a fallacy. So as we introduce the options, as more and more people began to realize these things have changed now, there was also sort of a getting stuck in many situations. This involved parties and arbitrators that had different desires when it came to the issue of doing and send it back to us, but creating its own set of problems. So we then created an option for in-person. Just like video ready, there's a box arbitrators could check for in-person ready, and for parties to check saying they wanted a panel of only in-person ready arbitrators. But there's lots of pushback from many arbitrators on this issue. They raised some good points. One thing they said was that it would put more senior and more experienced arbitrators at a disadvantage because they were the ones more likely to resist being in person, because they tend to be older ones. And another very good point that I hadn't really thought through was that in many cases, even an arbitrator is unwilling to do in person, and the parties wanted otherwise. If the arbitrator was appointed, the arbitrator could then discuss with the parties and talk about how the hearing would be run, and in many cases, we're able to convince the parties. We ended up saying, well, the parties don't have to check either box, and or they could check both boxes, and we encouraged that if parties wanted to be able to have a choice. There's an interesting phenomenon, which is basically that despite all these choices and despite making it very visible to parties, most parties were not checking either box, and that continues to be the case. So the panels tend to be mixed panels. Not sure why. Maybe it's because the parties could not agree on which, if either or both boxes to check, or it may be because they, despite the notice that we gave, they may have simply ignored the option. But it did populate on the arbitrator bio that the parties get. I don't know though if they would notice that on the bio, and if it was a consideration in the process of selecting an arbitrator from the panel that would provide it. Just to give you some idea of the numbers at this point, we have almost 1,000 arbitrators. Of those, more than half, 593 as of today, self-certify as video capable. 679, well over half, declare themselves as in-person ready. And about half check both boxes, say that they can do it either way. And basically, it will be up to the parties. What are some things that we've been seeing in all this? Well, we've had emails and phone calls from parties, one or both parties complaining about this or that regarding virtual versus in person. Ditto for calls and emails from arbitrators seeking advice or complaining about what was going on. And a wide range of issues. Some examples of refusal to schedule hearings, refusal on the part of the arbitrator to order a video hearing over the objection of one party, arbitrators withdrawing from cases, as I mentioned before, where they didn't want to make up their mind when the parties didn't agree. We saw some situations where one or both parties were manipulating things in reference to the very issue of virtual versus in-person. We had some complaints about excessive charges by arbitrators for conducting a virtual as opposed to in-person hearing. There were a number of cancellation of cases and still are when COVID increases in a particular area. So lots of arbitrators, I don't want to call them crybabies, but they were saying, I'm not comfortable ordering a video hearing over the objections of one of the parties. And so this created a problem. And the National Academy of Arbitrators issued an advisory opinion called Advisory Opinion 26. And they said, and quoting, the arbitrator will decide whether the matter will proceed by video hearing based upon the arbitrator's judgment on whether the circumstances are so compelling as to override the usual presumption in favor of consensual scheduling practices. Basically, and the opinion goes on, but basically what they are advising is a weighing of the factors by the arbitrator to determine whether or not it would be appropriate to order a video hearing if one party objects. If both parties object, then the arbitrator does not have the option of ordering a video hearing. Some considerations that we've seen in this whole surrounding this whole issue of video arbitration. These are examples. Who will provide the platform? Will it be the arbitrator, maybe a court reporter or an outside contractor, or will it be one of the parties? That's been an issue. How do we handle documents and also the introduction of exhibits and so forth? Will there be transcripts or recordings of the hearing? What are some implications for preparing witnesses to appear in this virtual setting? It's not the same. There's the issue of time lag. There's always a lag between what you see and what you hear, even if it's very small in a virtual setting, and that can make things a little difficult. Issues about what equipment to use, what platform to use, what features we need from a platform. And then many were concerned about the possibility of cheating, that if you're just on video, somebody could be alongside you, hearing you with answers, or you could be looking at notes or something like that. I don't think that that's so concerning, because I think that becomes obvious, and if anything, it kind of distracts from answering questions, and I actually think that kind of cheating would be counterproductive, but that's just my personal opinion. So the big question is virtual arbitration here to stay? And I think it was Joe DiMaggio who said that the problem with the future is it's so hard to predict. So if and when the pandemic is behind us, well, I think that we will see continuing interest in virtual arbitration. A great many, an increasing number of arbitrators, parties, and advocates have discovered virtual arbitration. They've experienced it, and now many of them use it frequently. They see that it really can work. And there are lots of advantages to it. Some examples are cost savings, convenience, the speed of the whole process, better access to court reporters and interpreters, as well as to advocates. So you don't necessarily have to use a more local advocate. Use the best in the country that you can find. Also, it leads to greater civility, and one reason for which it's kind of harder to interrupt, at least in a timely fashion. And so parties tend to be, many parties are civilized anyway, but what I'm hearing is that tends in general to be a more civilized process. And also, in many cases, witnesses are more at ease because they're often in their home environment or a comfortable environment, and that they're not sitting in person in front of essentially a tribunal. So it makes witness testimony perhaps flow a little better. There are disadvantages. Chief among them is, of course, technology. There are always frustrations with it, technology, glitches can come up. I think we continue to improve with that, but that's an issue. Many have had privacy and security concerns, but I think those have largely been addressed, and are, that's continuing to improve. And then there's that big disadvantage for some, which, where the arbitrator can't get the cut of the witness's jib. Anyway, overall, I think that virtual arbitration is here to stay. I can't be sure if it will be as much as during the time of COVID, if and when COVID is more or less behind us. So it has indeed been my pleasure. I thank you for joining in, and I'm going to say goodbye and wish you all well. And do feel free to get in touch with me if you have any questions and you want to discuss any of these issues. I'd be very happy to talk to you. Thanks very much, and enjoy the rest of the conference. I'm sorry I can't be here with you.
Okay, so we had a little bit of glitch because we lost a internet connection during Pat's presentation. Pat is back on, and like Pat mentioned in his comments, we are tracking all of the chats. Feel free to put your questions in there, and Pat's back on, but we're going to go on to David Larson now. So David, can you take over with your screen share?
Yes. Well, thank you for inviting me to speak today. Thank you in particular to Patrick and Dr. Obar for this fantastic report. There's a lot of detail in it. I encourage people to look at it. I think some confirmations are expected, some are a little surprising. It was interesting to see the tactical use of concurrent caucusing, which I think if we think about it would be expected, that people are using texting while they're also on screen, but some tactics are different online, and I thought they did a nice job of identifying those. So what I'm going to talk about today is, so we have EEOC mediation. What's next? You're mediating with Zoom and Teams. If you're merely moving an offline process online, is that truly ODR? Well, in the ODR community, I've been doing ODR for over 20 years. There's an ongoing debate. Some would say that whatever technology you're using to supplement or replace things you've done traditionally would be ODR. And there's an organization called Resolution Systems Institute out of Chicago that would say that. But what about other technologies? Is it really just communication technologies? What about algorithms, blind bidding, machine learning, artificial intelligence? Shouldn't we be thinking about those possibilities when we talk about online dispute resolution? National Center for State Courts would say, yeah, we should think about that. And if you're using a platform that was explicitly and expressly designed for dispute resolution, then I think that's ODR. So that's not to say that you're not doing things online. I think this is really a continuum here, a spectrum of being purely face-to-face and then integrating different levels of technology. So I don't think it's a bright line between yes ODR and no ODR, but it's much more of a continuum. To what degree are you using technology and how deeply are you using technology? And what I think is that in the future, you're going to be using technology a lot more deeply than you are today and than we are in the EEOC mediation program. So should ODR be a term of art? Well, I talked about different terms: technology mediated dispute resolution, technology assisted dispute resolution. The reason why it's important, because if you're going to draft standards for how you should behave, it helps if you know exactly what process you're talking about. And to draft standards for that entire continuum becomes a little more challenging, not impossible, but if everybody has a different perception of what ODR is, it's a little harder to come up with some standards. So as we saw from today, whenever you're using technology, there's always going to be some challenges. You always need to have a plan B in mind. Can ODR improve access to justice? I've been convinced it can for a long time. People can't appear in court because of shame, fear, no vacation time, transportation issues, childcare. Maybe they're physically intimidated. The report from Patrick and Dr. Obar talk about lots of those things. Maybe it's a disability. I think ODR can improve access to justice, but we have to be careful. And I think disability is, for example, one of the concerns where, yes, it can help, but also can hurt. That when we move into a digital environment, we have to make certain that we are disability accessible in that digital environment. When it comes to audio, when it comes to vision, there are things we need to do to make certain that we're not excluding certain people because of disability, for instance. Things like digital divide also are important, that people have access to a broadband and a fast band. So what technology are you going to create or adopt for your ODR system? What are going to be your standards, ethical principles? I'm just going to refer you to the International Council for Online Dispute Resolution. They have standards that there's a hyperlink that's active that gives you more complete descriptions or explanations of what these terms mean. But basically, any ODR system should be accessible, accountable, competent, confidential, equal, fair, impartial, neutral, legal, secure, and transparent. I'm chair of the ABA section of dispute resolution right now. I'm also co-chair of an ABA ODR standards task force. We're just about done completing a 3-year project to draft standards for ODR in terms of ethical and responsible behavior, and we should be releasing those soon. One thing about moving ODR, a colleague of mine wrote an article about mediators' dirty little secret years ago, that mediators really can affect processes and outcomes by their behavior. I think when you go online, you have even a greater ability to do that. I think one thing we don't talk about very often is that when you have a neutral operating online, often what they do first is they introduce people to the platform. They become, and particularly I'm talking about now mediation, they introduce people to the platform. They get perceived as the answer person, the expert person. They're the ones who are going to explain what's going on. But then you've finished that orientation session. Now it's time to begin the mediation session. And sometimes it's difficult to switch hats. It's like you have now positioned yourself as the answer person, the expert, and now you're going to be a peer facilitator. Maybe not. I think that transition might be difficult, and it might be well advised to have somebody else do the orientation of the platform when I'm speaking really about mediation, and then the mediator do the actual dispute resolution, and avoids that kind of a conflict. ODR has been used around the world. I'm giving the information that you can look at later. www.odr.info has a list of jurisdictions around the world. They have 128 there. I think one of the really good examples is the British Columbia Civil Resolution Tribunal. They've been doing it for a number of years. A really developed 2-tier system where they have a solution explorer that goes through at kind of like a TurboTax, kind of deconstructs your dispute through a kind of a tree analysis. You answer one question, it takes you to a different set of possibilities depending on what answer you give. Spent millions of dollars putting this together. So what they do spend a lot of time is orienting and educating the parties before they ever begin the dispute resolution process with the Solution Explorer system. And then you go into the actual dispute resolution platform. China has been using it for a number of years. The UK has been using it. EU has been pushing for online dispute resolution. I just stuck this on there. That's a lot of text, but just a couple of days, I got this email a few days ago from somebody in Greece who's saying, we got a new version, end-to-end ODR. Here's the website, www.adrforall.com, 3-year project supported by the European Commission, EU. It's integrated with the European Union. It's just an example of what's happening around the world as countries are moving towards adopting ODR. Here's a map. If you blew this up, all those little location indicators would expand out. There's over 100 jurisdictions in the United States that are using ODR right now. That website I gave you, www.odr.info, will list all of what those sites are. But it's interesting to see how quickly ODR is being embraced by court systems around the United States. I've been working with New York since 2016. We started with a debt collection project back in 2016, 2017, 2018. We got some surprising resistance from legal advocates who are afraid that putting debtors in virtual spaces with debt holders would be unfair. We learned in that first iteration of the New York project that it's important to be as transparent as possible, which we did for a full year. We reached out that you've got to anticipate conflicts and tensions with state government policies because what you're trying to do may not be consistent with rules of procedure, for example. We decided to contract out the building of the platform. Then one of the problems was you can't give out all the information about the ODR design to selected groups, for example, legal advocates, before you do the request for proposals, because the fear then is that you've tainted the request for proposal process because some people got the information earlier than others. And I think that was one of the communication problems with the first iteration of the New York credit card debt collection, that they couldn't really share how consumer protective the entire program was for fear that they would taint the request for proposals process. One thing I think is really helpful is if you're trying to build ODR into a court system, you build it top down, not bottom up. We started trying to build bottom up, getting grassroots support and bring it up through the system. Utah was very successful in implementing their court program in the small claims court, and that's because of Judge Dina Homonis, Supreme Court Justice, who was behind it and kind of led the charge from the top. Is ODR better? I think it's better even for debt collection. What's happening in New York was that debtors would come to court underrepresented. Debt holders would call them out in the hall, try and find them, tell them, look, I'll give you 50 cents on the dollar. People would say, oh, that's great. I'll sign that agreement. But there are acceleration clauses that say if you're a day late, then the entire debt will come due. They sign those agreements, go in the courtroom. The judge approves it. It's court judgment. You can now attach property and garnish wages. It's unrealistic to think that the judge is going to take the time to walk everybody through those agreements. In at least our ODR platform did provide legal information, provided all kinds of hyperlinks to legal services. You could always exit out of it, but I think the relevant comparison isn't to the ideal. The legal advocates would say that if everybody's represented in court as a debtor, they will come out better, but that's never going to happen. There's never going to be funding that every single debtor is going to have a legal advocate provided by the state or the county. And so what happens is they're unrepresented, and I think they either don't ever show up at all, or they sign these agreements and they really get disadvantaged. So for an example of an ODR system that goes beyond just video mediation, we have a New York small claims court system. We're limiting the kinds of cases. Originally, we're not going to have real property, landlord-tenant, third-party actions, public agencies, domestic violence cases, order of protection, no attorneys. We've expanded that. Still no domestic violence history, order of protection, no clients with attorneys, New York municipalities, no employment wage claims. I put that in there because of this conference. I've always thought that wage claims, wage and hour claims would be perfect for ODR. It's just not being used very often for that. And I encourage people in LURA to think about how ODR can be used for wage and hour claims. No cases with counterclaims also. We have ask hard opt-out questions. If you say yes to these questions, you're not going to be able to continue in the ODR platform. Do you have an attorney, history of domestic violence, order of protection? Then we have a series of soft opt-out questions. And I like these soft opt-out questions because it leaves it to the party to decide whether or not they want to continue. So just for example, are you comfortable saying what you think and standing up for what matters to you? You might say no, but then you think, but my partner always is with me and they help me and I'd still like to continue. So even though somebody might say, I'm not particularly comfortable, I may still want to continue because there's a way I can do that. And that might be true for all of these questions. You might have difficulty in English and maybe you have someone can help you and you still want to continue. So we'll leave the choice up to the parties and nobody else can see the other answers. So what the process looks like, you can initiate it online or in person. We have animated videos talking about what small claims is, what ODR is. We have blind bidding where you have 3 rounds. People just submit bids blindly if you get the overlap of what you would be willing to pay. You've got an amount now to work with. If you can't do it, you get a last chance to do a direct negotiation, a direct conversation between the parties. If you can reach an amount, then you have a structured negotiation to figure out the payment terms and the time. If you've reached a settlement agreement as to amount and terms, it will auto-populate the agreement. At this point, and this is, I guess, the most noteworthy thing, there's no human intervention, except that we allow for in-person filing of the case. So the clerk may be involved, the court clerk, but you can also initiate online. Just to be consistent with rules of procedure, we do a service of process through the clerk of court, and then the clerk of court reviews the eligibility questions just because we want to make sure about that. But with those exceptions, what this is a closed system where you don't need human intervention, and it's entirely possible that somebody can go from the initiation of the case to the resolution and the auto population of the settlement agreement without any human coming in with those couple of exceptions. If you can't reach it, then we do have online mediation with community mediation centers. That involves a little more coordination and training and working on things like consent to agreement. So last slide. What more did we learn when we moved from credit card debt collection to small claims? Well, we're using our own, we have to decide you can use your own vendor or build your own platform. Build your own platform, you retain control, but you're gonna have to update it, you're gonna have to maintain it, you're gonna have to train people. We decided to go with Matterhorn, but now they were bought by government brands. What that means, you have all new personnel. So that requires an adjustment and an education curve. You have to be flexible. We lost our court hearings through the pandemic. The incentive to engage in ODR went away. You used to be able to say, if you don't do ODR, you're gonna have to go to court, but there were no court dates. So now you say, we'd like you to do ODR, but there was no real stick there. And it was difficult getting parties to engage because they knew they weren't gonna have to go to court because there were no court dates, although that's starting to change. During the pandemic, there was reduced staff, the court clerk was transferred. So you have to be ready for those kinds of changes for supporting the system. And defendant engagement, it will be challenging because, why should a defendant engage when if they can keep running, they'll never be liable? What's their advantage? Some people will say, it's my advantage to put this behind me. Yes, I want to engage, but other people will say, my goal is to never be found, never be caught. If they know they're going to have to go to court eventually, that would be helpful. And we're getting back to that now. So that's a lot. Don't hesitate to contact me. I just think we're moving to a world where we will be using more automated processes than we're using now. I think that's just inevitable. Okay, thank you.
Thank you very much, David. Steve Ekonowski from the EEOC, you're up. And we'll follow that with any wrap-up comments by Pat and then any discussion. So go ahead, Steve.
All right. Thanks, Bob. Everybody can hear me okay? Thumbs up? Good. I think one question was answered today by Pat's disappearance. Having worked with him for 22 years on and off with these things, what does it take to silence Pat McDermott? And it's an act of God. I have no other explanation. We've tried many other interventions and this seems to be the only. Anyhow, I know that for many of us, let's put it this way. First of all, let me thank Lyra and Pat for inviting me to do this because it is rare that the subject or the program that's being evaluated gets to talk about the evaluation. Usually the people who write the reports have assessments and whatnot, but rarely do you get some sort of that inside baseball behind why we did what we had to do and why we did it. And I'm extremely proud to be representing the commission today based upon the results that were found in those 2 studies that we commissioned Pat to write. And they were targeted, and if you read them, they're very centered on EEOC's program. And now whether those findings can be expanded to other avenues, into other personal mediations where people still participate, it's not devoid of personal interaction. Whether that can be extended to other things, I think is the question for academics and other folks. But for practitioners in the EEO field, particularly with EEOC, our successful transition was made under some really difficult and unique circumstances, obviously COVID. So I think missing Pat probably missed some of the key data points, but I'm going to focus on what we found to be particularly of interest to us at EEOC, because I don't want to go out of my lane. I do agree that that this video mediation, or if we call it online dispute resolution, is definitely here to stay. And that was one of the key findings that Pat would have consisted. So from April 99 to March of 2020, we did everything in person. So you came into the office or another site that we had prepared for you, and a charging party, their attorney or representative, responding attorney for the company, or a representative of that company would show up. Charges filed with the EEOC, and if the parties voluntarily want to participate in mediation, and EEOC thought it was the type of case that should go to mediation, you could go to mediation in person. Well, overnight, I think the date was March 13th, March 14th, we found out that we could no longer do this in person. So what do you do? It's a real life problem. I think when you do research, you tend to forget that behind each of these charge numbers and each of these surveys are people with real issues, people who filed with the EEOC, people who had a claim and wanted some sort of intervention prior to going to a full investigation in the hopes of settling it so that they can move on. I think the pandemic heightened that because we still have those vivid recollections of people without jobs, not knowing if unemployment would cover some things, people going to food lines, didn't know when their next paycheck was coming, would workers' comp kick in to cover some of the things that were done. And again, what we had to do basically over a weekend is to figure out what to do, because you have to also remember that there were cases ready to go. Our guys schedule out 45 to 60 to 70 days. So you just can't postpone them because that would put them at the end of the line. So we tried to figure out what to do. And in doing that, one of the things I think that also gets lost in the shuffle of all this is that EEOC operates under certain laws and certain statutory constructs, certain case law. And in addition, there are other avenues for charges to be resolved through EEOC. You still have the right to an investigation, perhaps litigation, and then if the EEOC can intervene at that point, conciliate the claim. So we had to adapt and adjust within a framework. It wasn't just like, go forth and do this any way you can. We still had to protect those rights that had accrued either through practice or case law or administratively, some of the things that people were used to. We wanted to stay as consistent as we could. So the million-dollar question was, how do you take a program that conducts 10 to 11,000 employment discrimination mediations a year, and how do you maintain that structure, but how do you maintain the quality of a voluntary program that resolves 3 out of every 4 cases in a new format that people were used to? Again, heightening to what some of our previous, David and Alex had said earlier, that I'm not sure that people were used to it. There's a fear of using technology. And also, one thing that David mentioned clearly is something that EEOC was concerned about, the digital divide. Some of the people who file cases with the EEOC don't have hotspots, don't have tablets, don't have access as readily as some of the other people. So we also had to take that into consideration. So what we did very early is just do what we could with what we had. And to that, what I mean is we would continue with phone mediations. We continued with Skype when that was available. We did combinations of different things. We did hybrid information things. Sometimes we borrowed some of the things that we use for the federal sector employees. The federal employees have a separate EEO process. And there are standalone video components that are very bulky, that have very narrow bandwidth, to the point that it's possible while you're conducting 10 federal employee mediations, it tends to pixelate. You could also pick up audio from another hearing while you're doing your own hearing. I remember that as being an AJ. So we pitched and patched, and we tried to figure out what we could do until Microsoft developed, extended our teams, extended our platforms, added teams to what we had on our government computers. And while that was going on, in a parallel world, you had the Zoom company, which was in its infancy, and we started to hear some very good things about it. We automatically went to Zoom, and because there was COVID money to be spent, we were able to get about 100 licenses for Zoom that we quickly trained our people on, so that by July, early August, maybe a little bit later, depending upon the office, we had some sort of format in a smaller screen, whether you used your phone at home, but we were using our power at each, our hotspots that we sent out to different people, our personal internet capacity to try to get this done. Now, we didn't know what to expect, but one of the indications to us that this was successful and this might be something to pursue were the anecdotes that we were receiving from parties, email saying, I can't believe that you guys figured out a way while we were at home worrying about our checks, while we were worried about, being able to take care of our kids, our benefits, et cetera, that you figured out a way to conduct something so that things could continue. And they were just grateful to have the platform. And when I say grateful, that probably understates what they meant. They were so happy that someone was listening to them and tried to adapt and adjust to them. And then the second indicator we had is we have, in addition to the qualitative analysis that Professor McDermott did, we obviously have our usual quantitative sets of data that come out. And what we saw was that the quantitative the numbers that we were seeing from our IMS system, as we call it, was paralleling pre-Zoom type activity. 70% plus were settling. We saw the same rates of participation for charging parties and respondents. We were able to fill up and more than fill up the available spaces for folks to do this from home. And it was encouraging, but again, having had that baseline of information from 2000 and some of the interim reports we had, we were still very, very concerned about the qualitative aspects. We knew it was working for what it was. Was it a stopgap? We wanted to know what was lost and what we really needed to look at. So again, we knew that there was a concern, but with this high volume of cases, you wanted to make sure that it was more consistent throughout as we got better and as the platforms got better. I think within a month of getting Zoom came out with Zoom for Government that addressed some of those issues of Zoom bombing. I think you may recall the famous one of the individual in the Houston office. I think it was EEOC, where the cat appeared on the attorney's head, someone Zoom bombed. We'll take credit for that too. So Zoom for Government improved. So what you saw was this need that was expressed universally to many, many, many fields, businesses, but it was recognized that we needed to continue to do business. And we viewed, I think, the people who filed with us more as customers. Now, we do that. We always talk about customer service to our clientele. But when you file a claim in court or file a claim with the EEOC, you tend not to think in those terms, but we really had to see what worked and what they would agree to and what they would come back to. That was another thing we were considered. So I'm guessing everybody here has different areas that they will focus on. I was looking at the menu of topics today, and boy, oh boy, there are so many things that fall under, as David mentioned, ODR can be many, many things commercially, but how do you maintain that personal touch? And so we had these two studies that were done by Pat to look at what the mediators thought, to triangulate against what the participants thought. And he also could use some of the in-person results that we got, some in-person surveys that he did over the last 20 years. So by able to taking these 2 or 3 different things, triangulating them, you could come up with some really important conclusions. And the first one is the one that EEOC sometimes publicizes, and that is throughout the use of online, I want to say video mediation, so that people don't get confused about different types of online things, that the study meets or exceeds a lot of the benchmarks that we had before. But the big one was that between 92% of the charging parties, people filing, and 96% of the employers would come back to a mediation if another claim would arise. It was like the backstop measure, giving looking at everything that you know from your participation with the EEOC and knowing what you got. Maybe you didn't get what you want. And these are some people who didn't even resolve their matter. 92% of the people who filed said they'd come back to a future one. 96. Really, really strong, important measure of fairness. Secondly, and this one surprised me, and it was just so stark that I wanted Pat to redo it a few times to make sure, is that the access to justice measure, which sometimes gets lost in the shuffle, was very, very, very high. And in some instances was rated higher in some of the questions because of the accessibility to participate. And those results in and of themselves, when you just look at the qualitative analysis, that's very powerful. But what was even more impressive, those results were buttressed by some of the open-ended comments we received to some of the open-ended questions that Pat asked. And you'd see people saying, wow, your mediators, picked quickly up on some things that maybe the behavior in person wasn't the same. It was more nuanced, that they picked up on what the needs were. There was more focus. And that access to justice translates into their ability to have their voice heard. And that was another issue we were concerned about, the preservation of a person's ability to have their claim stated, their voice. There's also clearly an adoption and a preference now for screen mediation, but EEOC, of course, will always be able to do in-person mediations for those individuals who can't or don't want to be there. And finally, a couple points. I don't think there were some obvious things that don't come out in traditional mediation. There were some common sense efficiencies: the cost of coming in, the cost of parking, the cost of gas, the need to have babysitters instead of being able to do things from home, so that people were more productive in a 4-hour period than taking an hour, hour and a half to get to the mediation session. And finally, I would be doing a disservice to everyone who had a hand in this transition to the online video mediation if I really didn't recognize the unbelievable flexibility and adaptation of skills that our mediators, both internal, contract, and our staff, who have to schedule and do 9,000 to 10,000 of these cases a year. You can take credit, and a lot of people will in the future, my guess, but you can have the best plans, but if you don't have the people who carry it out and do it willingly and really understand what's going on and go behind the charge numbers to help people, it really is a more of a reflection of the dedication and hard work that these folks did, doubling up on cases, figuring out things, and then running with it as some of these platforms became available. I think that's what I wanted to say. I don't know if Pat wants to jump in. I know that we're kind of time barred because of the circumstances, and there's always a loss when you try to get as much as you can in an hour. So Bob, Pat.
So
I
thank
would
you very
just-
much, Steve.
I would
Pat,
just
do you
say.
want to, Go ahead,
I would just
Pat.
Say hello and goodbye, and everybody said it so much better. And I believe, like Schumpeter talked about, the creative destruction inherent in the capitalist model and the market system, that David is a market leader and visionary. Steve and the EEOC accomplished an incredible task without a playbook. And the future is very exciting, and I see great change based on the hard data. So please take a look at the report. Thanks, Bob.
Thank you very much to our panelists and all those participants. We'll be putting these things, the presentations and the recording up for anybody to view at a later time. Thank you, panelists. Have a good day.